One thing that I have been asked to do, and in some ways the disjunct it doesn't really bear thinking about, and that is I've been asked to talk a little bit by way of introduction to the issues that have been raised by the report issued last Tuesday from the public inquiry, the statutory public inquiry into the mistreatment and abuse scandal at Brooke House. Although that was in 2017 and the inquiry only reported last week, everything that is in those findings that the chairwoman has made are highly material to the current practices with respect to detention, because it was clear and evident throughout the whole inquiry that no lessons had been learnt by 2021 and 2, when we were having the public hearings and evidence was being called from the Home Office, its contractors, the healthcare providers, even the independent scrutineers in the IMB and the Chief Inspector of Prisons. And so it's evident, and she's made it clear in her findings, that very little, if any, lesson learning has been done. What was operating at Brooke House in 2017 continues to be the same situation now, and it has critical importance for any case that you bring in terms of the lawfulness of the detention. And just by way of the summary, we'll do a more detailed specific seminar on it, because there is so much in there that is of direct relevance to our work. But essentially the key headline findings were of evidence of 19 separate incidents of Article 3 mistreatment over the very short period of time that the inquiry's work was covering, which was 5 months period, and it's only the period, the incidents which could be established by video footage or by were not contested. So, and it was absolutely clear from the undercover reporter that these were only the tip of the iceberg, and that was also found by the inquiry's own expert on use of force, because in the absence of the use of body-worn footage or other forms of CCTV, there is no independent, reliable record of abuse and misuse of force, because nothing that those people record in those facilities when there are allegations of abuse and misuse of force can be relied upon. So 19 separate incidents, widespread misuse of force and the power of segregation. Both those powers were used routinely, not as a last resort, and not in accordance with the common law or with regulations. There was a wholesale failure of detention safeguards, particularly, and come of no surprise to people in this room, for vulnerable people. Complete dysfunction in Rule 34 and 35, and that was in the context of very substantial and significant failure of healthcare providers, to even understand the rules that they were supposed to be applying, never mind applying them, and clear compromises of their professional and ethical duties in terms of their role with regard to the protection of the rights of what are obviously their patients. The head of the GP provider contractor, Dr. O Ceallaigh, was referred to the GMC. That indicates to you how significant those failures were, and were part of what was described as a complete deprivation of safeguards by the inquiry expert looking at the medical issues. This widespread failure of the legal framework and protections was in the context of what was described as a toxic culture that had a number of features. It was both macho, aggressive, and extremely violent, but it was also desensitized, dehumanized in treatment of detained persons through processes of othering, utter disregard for human suffering, and also racial discrimination, both direct and indirect, overt and stereotyping that was widespread and directed to and at detained persons. On top of that, and not surprising given that this was only really exposed by undercover reporting, the inquiry found that there was a failure of the oversight mechanisms, both the IMB, whose independence was even compromised by their relationship with G4S and the Home Office, and even the Chief Inspector of Prisons, had failed in their role to act as effective monitors of the rights and against mistreatment, although the inquiry importantly made it clear that it was wrong for the Home Office and G4S, but particularly the Home Office, to seek to offload its responsibilities to independent monitoring bodies, the inquiry making it absolutely clear that it was in fact the Home Office who has overall responsibility. They exercise the power to detain, and they have the duty to oversee and ensure that those facilities and its contractors operate lawfully. So that's the headlines. What it means and what will be important for our work is looking at the threshold that was set by the inquiry for what constitutes Article 3 mistreatment. And we all know it's going to be a high threshold, but not as high as one would have expected, because if you look at the individual cases, one individual who was subject to a number of officers in full PPE, kitted out in riot gear, coming into his cell to take his other cellmate to out of Brook House, a shield put on his chest. That was credible evidence of degrading treatment. So it's important to look at the individual cases when you're coming to consider assaults, because this is routine. This is not unusual. This is happening probably 3, 4, 5 times a day in Brook House right now and across the detention estate. And it's important what the inquiry said about also the nature of the unlawful use of force and the assaults that were occurring, again, on a routine basis, because there was a failure. It was default resort to force, including to move people around the estate, obviously to deport them, but done without proper regards to whether there were alternatives, not as a measure of last resort, and again, routinely done in the most frightening, intimidating, and for often humiliating way, with large numbers of men in riot gear, having no regards to the vulnerability of the individuals who they were dealing with. There was routine failure to properly authorise segregation. It was used as an inappropriate means to manage mental ill health. And of course, it confirms this systemic failure in the adults at risk policy. So although Mr. Neil has lost his job for repeatedly telling the Home Office that they were failing in their detention safeguards, the inquiry has made it clear that he's been absolutely right, which he's consistently been saying since at least 2018. But of course, we've all been saying it in many different ways as lawyers and as NGOs and as doctors and practitioners, that there's systemic failure in respect of the protections for vulnerable people. But it's certainly, all of this is in the context of an environment that was generally violent, insanitary, dirty, no respect for human dignity. And so all of that is going to play out in aggravated damages for cases, obviously at the time, but I think a lot of the features will be there. And of course, they do impact on exemplary damages if you have any conditions that replicate what was happening at Brook House. And sadly, we can be confident that there will be replication across the whole system of those dangerous, unlawful, and utterly brutal and unacceptable conditions. So that's the context in which we're now going to consider the government's decision to actually reduce the safeguards for people in detention and end the practice that there had been, at least since the Shaw Review in 2015 and the ending of the Detain Fast Track, to reduce the numbers of people in prison. Obviously, they've made a commitment to detain anybody and everybody and massively expand the detention facilities. So obviously, what legal protections are left and what arguments we have is now critical. And on that very long introduction, which I hope you'll find of assistance, I'm going to ask Greg to talk about the impact on the Hardale-Singh principles. Greg is as I'm sure you're aware, barrister at Garden Court Chambers, who specialises in human rights and asylum and immigration. He has a wide practice that covers both civil and public law, and has a very substantial practice that focuses on unlawful detention cases, and that he's honed that practice over the 15 years of experience at the bar. He also is the author of the chapter in MacDonald, and have been doing that for some time.
With you.
I only edit it. I do the corrections, but there's not many to be done. So, that shows you that his level of expertise. And of course, he appears across all courts. And so what he's got to tell us, I hope we'll find of interest and in use as you go forward.
Thank you very much, Steph. So, I want to talk firstly about Section 12, Hardale-Singh, and I think this is a hugely significant piece of legislation for a number of reasons. When I was first coming to the bar a long time ago and thinking about it, I remember very well the debates about the possible introduction of 90 days detention for suspected terrorists. What this piece of legislation is intended to do is give the Secretary of State an indefinite power of detention effectively for IT consultants who've overstayed their visas. It's difficult to overstate how potentially serious this is. I'm just going to focus on Hardale-Singh 2 and 3 and the codification of the grace periods, which is what's coming into effect tomorrow, as I understand it. Yeah, tomorrow. So first of all, Hardale-Singh. A lot of you in this room will be very familiar with Hardale-Singh. It's worth looking at the principles again. Established in the case of Hardale-Singh, which was done a case by somebody else in these chambers some 30 years ago now, and were codified in the case of I by Lord Justice Dyson in the following terms. There are 4 principles. First of all, the Secretary of State must intend to deport a person and can only use a power to detain for that purpose. So he can't detain people for the purposes of preventing crime, for example. Secondly, a deportee may only be detained for a period that's reasonable in all the circumstances. Thirdly, if it becomes clear before the expiry of a reasonable period that the Secretary of State won't be able to achieve deportation before the expiry of a reasonable period, the power shouldn't be exercised. So Hardale-Singh 2 says, have this person be detained for longer than a reasonable period. Hardale-Singh 3 says, looking forward, is it clear that we won't be able to deport a person for the expiry of a reasonable period, in which case the power should no longer be exercised. And the 4th principle is that Secretary of State should act with reasonable diligence and expedition to effect removal. Now, those principles have been honed in the courts over many years. And the first really significant case on the Hardale-Singh principles is the case of A from 2007. And it was held there by the Court of Appeal that in assessing whether there is a breach of the Hardale-Singh principles, the court itself has to make findings of fact, and the court has to decide whether a reasonable period has been exceeded. What it said there is that there's no place for a Wednesday examination. That information, however, is to be considered on the basis of what was before the Secretary of State. So if the Secretary of State didn't know about something, then you can't take that into account in assessing the reasonableness of the period, and the case on that is MH. It's been said, importantly, in the case of Lumba, that the Hardale-Singh principles only do that which Article 5.1f does. They require that the power to detain be exercised reasonably and for the prescribed purpose of facilitating deportation. The grace periods are something that have evolved subsequently. Now, in 2011, the Court of Appeal identified the concept of grace periods, holding that reasonableness in Hardale-Singh applies equally to the moment of practical termination of detention as it does to the question whether to detain at all. What that means, in effect, is once we've got to the point where it's no longer reasonable to detain a person any further, you get a kind of period of bonus detention, where you can detain them for an extra period that's long enough to make arrangements for them to be released safely. And there's an old saying, of course, that hard cases make bad law. FM was about whether or not a woman with a, I think, 7-week-old baby and 14-month-old child could be just released immediately, or whether the Secretary of State had to make arrangements for her to be safely released. And of course, that's not what it's used for now. What it's used for now is typically somebody who's considered to be some kind of risk of offending, and the Secretary of State says, reach the point where they can no longer be detained, and then starts looking around as to whether or not they can find them some bail accommodation. That can take a very long time. The grace period was defined by AC Algeria saying as the period of time allowed to the Secretary of State, once detention ceased to comply with the principles, to make suitable arrangements for release. And their use has expanded significantly. So Justice Irwin, when describing grace periods, says, well, once the second, third, or fourth principles are breached, then the question arises whether any further detention is lawful. I mean, the question answers itself. But anyway, he says it is. Only for a reasonable period to put in place appropriate conditions. How long it depends on the facts of the case, including history, risks to the public. Well, obviously, a risk to the public can't justify indefinite further detention, and you can't be detained just for the purposes of preventing crime. There can be no question that it's proper for officials to avoid such a question until compelled to release by the courts. Well, any of you who practice immigration detention will know that that's exactly what happens a lot of the time. You're not going to get bail accommodation turning up. You're not going to get a proper referral for release until at least a pre-action letter, if not judicial review proceedings being brought in many cases. But importantly in AC Algeria, the court says, when the question of a period of grace arises or might arise, the Secretary of State should be expected to advance some evidence and make considered submissions as to what period would be appropriate and why. And there's lots of case law as to the kinds of periods that might be appropriate. So, for example, Karani said 7 days in the period of in the case of a serious sex offender. You see much longer periods in other cases. So, Section 12. What does Section 12 of the Illegal Immigration Act do? Well, first of all, it says a person detained under the Secretary of State's detention powers may be detained for such period as in the opinion of the Secretary of State is reasonably necessary, regardless of whether there's anything that for the time being prevents removal or deportation. And once removal or deportation can no longer be achieved within a reasonable period, for such further bonus detention, for such further period as in the Secretary of State's opinion is reasonably necessary. And they're absolutely clear what they're doing here. They're trying to reverse the cases that they've lost. The explanatory notes say, as well as codifying in part this Hardy-Singh principles, this clause also overturns the common law principle established in A against Secretary of State for the Home Department and later authorities, that is for the court to decide for itself whether there's a reasonable or sufficient prospect of removal within a reasonable time. So that's what the Secretary of State's trying to do. Parliament. Did they do it? Have they got away with it? In the case of Tanti Lam and others, the Privy Council said this: their lordships do not exclude the possibility that by clear words, the legislature can confer power on the executive to determine its own jurisdiction. And there's no doubt that's what they're trying to do. Say, for example, the power to detain is expressly made exercisable during such period as in the opinion of the director, removal from Hong Kong was pending. In such a case, the court's only power would be to review the director's decision on Wednesday principles. So, have they got away with it? Is that what's happened? First of all, we say any detention powers will be narrowly construed, and the case in that is for Justice Laws, but it's an old principle that's been around for a long time. I don't see anything in the face of legislation that interferes with the court's power, and I would say duty, to make findings of fact. Secretary of State gets no deference there. There's a case called Fair News that I did with Stephanie and James Elliott from Wilson some 10 years ago, where it was argued with the Secretary of State that it would be for the it was for the Secretary of State to decide how long the period was reasonable, because if the judge did it, it wouldn't be objective. Whereas if the Secretary of State decided how long a period was reasonable, that would be objective. Although that didn't quite make it into the judgment in the end. But in the analysis for the Lord Chief Justice, he did say it's this objective approach, i.e. the court deciding how long a period is reasonable in all the circumstances. It's that objective approach which reviews the evidence available at the time that removes any question that the period of detention can be viewed as arbitrary in terms of Article 5. Now, one interesting aspect of this is that unlike the solution suggested in Lamb, the new provision doesn't provide that the Secretary of State can detain for so long as the deportation is pending, but how long the Secretary of State considers detention is reasonable. And it's difficult, in my view, to see how the Secretary of State could decide that a period of detention was reasonable in circumstances where it was not objectively reasonable. The court is going to have to look at those questions. The court's going to have to decide the facts. And if the court thinks that a period is not reasonable in all the circumstances, it's difficult to see how that would be lawful, even if the Secretary of State thought it was reasonable. We know she's a very reasonable woman. We see her on TV all the time. But even so, it's not inconceivable that she could be wrong about this. And in my view, the courts will have to decide that. And I think it's instructive to just look at what's said in Lumba. The Hardy-Singh principles reflect the basic public law duty to act consistently with statutory purpose, Padfield, and reasonably in the Wednesbury sense. What the Hardy-Singh principles do as they exist today is they provide that detention is reasonable in the Wednesbury sense. And that exact point is made again in Hamati, almost word for word, in 2019. So, the grace period, has that... what are the implications of that? Well, first of all, what it really does is, apart from the addition of in the opinion of the Secretary of State, that just really reflects what the current state of the law is following the decision in AC Algeria. However, it's not totally clear that grace periods are lawful, certainly by reference to Article 5, and Stephanie's doing a case called ASK in the United Kingdom, I acted with Alex Gimmick in relation to the intervention into that forbid. And there's a real question over whether or not grace periods are compatible with Article 5 for a number of reasons. First of all, it's arguably not detention with a view to deportation. Secondly, the question of a grace period runs directly contrary to the principle that Article 5 does not permit a balance to be struck between the state's interest and the individual's right to liberty. We know that from A against the United Kingdom. It's a core principle of Article 5(1)(f) that detention must not endure for a period that exceeds what's reasonably required for the purpose pursued. And if you're not being deported, it's difficult to see how your detention is still required for the purpose pursued. So, looking forward, where are we? They're not going to come into force till tomorrow, so we've got that little window. After that, my view is that I think we need to hold the line on Hardy-Singh. I think we need to be arguing that this makes no difference. And I don't think it's totally straightforward. But if you look at the case law on Wednesbury, it's an objective standard. Wednesbury is an objective standard. The Hardy-Singh principles, as currently drawn, are effectively a Wednesbury standard. I think that's a case worth making. I think it will have probably some willing listeners in the court. I think it'll be really important we try to establish objective facts and evidence, and often we try to limit the scope for the Secretary of State's views, because we already have a level of deference for the Secretary of State's views on certain matters in detention cases. And I think one real risk of this legislation is there's going to be more room for that. But the more objective, independent facts that we can establish in our clients' cases, the stronger I think the position we'll be in. We need to be thinking about using Hardy-Singh 1 more. So, for example, if Secretary of State says, well, sure, we can't deport you to Afghanistan because there are no flights there and it will be breach of Article 3, but that's just something that's for the time being preventing detention, preventing removal. And in my opinion, removal is still reasonable. Is that not a breach of our Hardy-Singh 1? Because you are not being detained for the purpose of deportation if deportation is far off in the unimaginable future. And obviously Hardy-Singh 4 is the deportation being pursued with reasonable diligence. Generally, it's not, is it? So I think that may be something we need to look at more as well. We also may need to get to the point. I mean, first thing to do is going to be hammering out what does Hardy-Singh mean now. But after that, we may need to look at whether or not Article 5 has diverged completely from Hardy-Singh, because what Lord Dyson says in Lumba about Hardy-Singh Article 5 just does what Hardy-Singh does, has meant that we just haven't had to rely on Article 5 in the same way in our detention JRs recently. And then maybe we're just going to have to go back there. We're going to have to start talking about proportionality. We're going to have to start talking about whether or not a Mikolenko impasse has been reached in certain cases. And we're just going to have to be flexible about that. It's also important to remember that the policies, some of which are in some places reasonably good, not many places. But we can still rely on them at the moment. And Lumba errors are completely unaffected by this. So I think overall, it's not that pretty a picture. But I still think that there is hope, and I still think that there is work to be done by people in this room probably to try and establish where the boundaries to the lawfulness of detention lie. And I still think that's a fight worth having.
Thank you, Greg. Just in terms of length of the detention, I should have said one of the headline findings of the Brookhouse inquiry was the recommendation of a 28-day time limit. So if you fail in your arguments, then the political battle is still around is there anyone in the country, the Labour Party in particular, that will take on board these findings? Yvette Cooper having said, when she was the chair of the Home Affairs Select Committee 2018 or 2019, 28-day time limit for everybody, whether they'll still have the courage of their principles and convictions, we'll wait and see. But we're next going to hear from Gordon Lee, who again is obviously a barrister at Garden Court. He too has a broad practice, public law and immigration, asylum, civil liberties and human rights. And whilst his work covers the whole gambit of immigration and asylum law, he too has a specialisation in immigration detention. Gordon was one of the juniors working with me and the wider team on the Brookhouse inquiry, so he may add some insight from that as well. He works on civil claims as well as judicial review, and has a particular focus on mental health cases. And he is going to talk to us about the other powers not yet in force that will come into force and that are complex in terms of how they interrelate with the substantive changes to the access to asylum or lack of access to asylum determination. So, Greg, I would Gordon, if you could. Two people so well. Name with G. Stop doing that. If you want to get on with your presentation, that'd be great. Thank you.
Thank you. Hi. I'm Gordon, not Greg. I'm going to try and do two things. One might be a bit dry, but I'm going to try and go through the new provisions in section 11, which aren't in force yet. I think it's only Greg's bit that's in force. Both Nicola and I are going to have to be talking slightly in the abstract. One of the features of this particular act is it does confer a number of powers on the Secretary of State to make her own regulations, and that means that we are sort of slightly shooting in the dark, because until that devil in the detail is revealed, I'm not entirely sure how all this is going to play out. It's also, I think it's fair to say, and this is a sort of broad comment, it's not entirely clear how much of it is purely performative and theatrical, and how much of it is actually supposed to work in practice. Because if you look at some of the notes attached to the statute, you'll see that during the course of the bill, lots of people came up with numbers, the numbers of people who might be caught by these various detention provisions. And if they detain everybody that's caught by them, there will be no capacity left in any detention centre or prison in the whole of the United Kingdom. One of the nasties in the Act, though, is that it does give the Secretary of State power to essentially name anywhere as a place of detention. So previously that was limited, but now she can simply point at a building and say that's a place of detention. Or a boat, or something between a boat and a building, depending on the planning laws. So there are a number of nasties. I appreciate everyone in the room is going to be familiar with, in particular, Section 2 and the removal powers. But I just want to deal with it very quickly, because one can't really look at the powers of detention without putting them in the context of the new powers to remove, because obviously they feed into each other. So just by way of the start, Section 11 is headed Powers of Detention. It amends three main statutory provisions. It amends Schedule 2 to the 1971 Act. It amends Section 147 of the 99 Act. And it amends Section 62 of the Nationality Immigration Asylum Act 2002. And it does so in order to take into account the new powers, or the new, to put it in a more accurate way, the new duties that the Secretary of State has in respect of certain categories of migrant. And so Section 2, I'll go through this very quickly because I appreciate you'll probably come across it, but there are 4 conditions. If someone meets all of these conditions, there is a duty to the Secretary of State to make arrangements for a person's removal. First condition is to enter without entry clearance, leave to enter, or an electronic travel authorisation, or having obtained leave by deception, or having entered in breach of deportation order, or being an excluded person under various statutory provisions. The second condition is that somebody entered after 20th of July 2023. Now, that date I suspect will be amended, because obviously since that date, the number of people that fall within these four conditions is accruing daily. And there's power within the Act itself for the threshold date to be amended. And if it's not, then the point I made at the start will be even stronger, which is that the number of people caught by these provisions would be simply unmanageable. So it wouldn't surprise me if that threshold date is amended. The third condition, which is obviously one of the controversial ones, which is that did not come directly to the UK from a country in which the person's life and liberty were threatened by reason of their race, religion, nationality, membership of a particular social group or political opinion. I'll mention it a bit later, but did not come directly is not given the usage that it's commonly given or accepted to have been given in international law. It's given a different usage in the statute. And the fourth one is the person requires leave to enter or remain in the UK but does not have it. And very nicely, if you have leave to enter or remain as an unaccompanied child, that doesn't count for that condition, so you can fall within that, come what may. So Nicola's going to talk in some depth about children, but I'll just cover it very briefly. So section 4.1 says there's no duty to make arrangements for removal of an unaccompanied child, but that the Secretary of State may make arrangements for removal of that child under certain conditions. And so those conditions are the child is to be reunited with their parent, to a safe country listed in section 80 AA1, or if there's no protection of human rights claim, to the country where they came from. And then the hidden nasty at the end, or in such other circumstances as may be specified in regulations. The section 4.4 provides directly that the regulations may confer the discretion on the Secretary of State. And there are various other provisions within section 4 which gives the Secretary of State various powers to make regulations, including adding exceptions for unnamed groups. One of the groups that was mentioned in Parliament was the Afghan settlement scheme, and there was some indication from the Minister that that is the sort of group that may be given an exception for removal. And finally, there's very limited exceptions within the Act for victims of trafficking, basically if it's necessary for them to remain in the UK to assist authorities. Right, so that's essentially the introduction. When it comes to the powers to detain, there is essentially a new paragraph 2C in paragraph 16 of Schedule 2 to the Act, and that creates new powers of detention, and they mirror obviously the powers of removal. So 2CA, detention pending the decision as to whether the conditions are met. 2CB, if an immigration officer suspects that the Secretary of State has a duty to make arrangements for removal on section 2, he may detain pending a decision as to whether the duty applies. C, if there is such a duty, pending removal in accordance with that duty. And 4, if the 4 conditions are met but there's no duty to remove by virtue of section 4.1, then there are new powers pending a decision to give limited leave, pending decision to give leave under section 8AA, pending leave as victim of trafficking, and pending a decision to remove an unaccompanied child. So as Nicola will no doubt come on, there are very specific and quite wide-ranging provisions both for the detention of children and making of further rules about the removal and detention of children. Some semi-good news. There was a threat in the bill to end a limitation on the detention of pregnant women. That hasn't made the Act, although there are only limitations in respect to the length of detention. So section 2D says that a pregnant woman can't be detained for longer than 72 hours unless that's authorised by a minister. And even in that case, she can't be detained for longer than 7 days. That's the only bit of good news that I think we're going to get tonight. So the section 2H permits the detention of unaccompanied children under the powers granted by the Act, but only in the circumstances specified in the regulations made by the Secretary of State. So sections 2I to 2K give the Secretary of State the power to make those regulations, doing things like specifying time limits, conferring discretion on an immigration officer, and wide powers to, and I quote, make different provisions for different purposes. So pretty much one of the widest powers that one could find in the statute at that time. The regulations must be made by statute instrument and are subject to the negative resolution procedure, which we're all familiar with. So section 11 also does a couple of other things. Firstly, what I mentioned earlier, which it removes the limitations on places that can be used for immigration detention, but it also removes the time limit for detention in what's called pre-departure accommodation in section 147 of the 99 Act. Section 13 is where I think, along with the Hardiel-Singh principles that Greg talked about, where the battleground is likely to first land. Because what Section 13 does is it amends Schedule 10 of the Immigration Act to prevent the first-tier tribunal from granting bail until 28 days after detention begins. So it is somewhat ironic, having sat for weeks in the Brook House inquiry listening to some of the most searing evidence you'll ever hear from individuals who've been utterly failed by those that were entrusted by their care, which led to a recommendation by the chair that detention should only be for a maximum of 28 days. We now have a provision that detention cannot be challenged for the first 28 days. So it is a sort of grim irony in the timing of the whole thing. The other provision, which is likely to lead to immediate challenges, which is the provision that detention cannot be challenged in court proceedings during that period. So it's essentially an ouster clause, retaining habeas corpus explicitly, but the only other exception is unless the Secretary of State or the immigration officer can be seen to have acted in bad faith or in such a procedurally defective way as amounts to a fundamental breach of the principles of natural justice. So that last sentence, or last couple of sentences, is pretty much precisely what was used in the Carte JR ouster, which I think the only challenge I've seen is a case called O Ceallaigh, and that failed on that point, that was seen to be a legitimate use of an ouster clause. Whether that survives in a jurisdiction concerned with liberty and the individual rights of detainees, I have my doubts. I think what will happen is either habeas corpus will be expanded, or questions of procedural defects and fundamental breaches of the principle of natural justice will be expanded to meet the context of liberty. There's plenty of authority which points to alleged jealous guardianship that courts have with regard to their role of ensuring that detention is not overused. Interestingly, in order for the ouster to get past some previous case law, decisions explicitly include purported decisions. So one of the arguments that one can take normally trying to fit an ouster clause is that the decision is so bad that it doesn't amount to a decision. That's explicitly excluded in the text of the Act. So the four, Greg was talking about what the future, my kind of offering as to where we might have some success in challenges in the future, really on these four potential challenges. So the first, it'll be interesting to see how the courts interpret the ouster clause in the context of detention and liberty. Secondly, it'll be interesting to see what challenges can be made with regards to procedural defects. I mean, anyone that's ever done an immigration detention case will know that there are procedural defects pretty much from day one. In Brook House just laid waste to any suggestion there was a proper screening process, any joined up thinking about whether vulnerable people should be detained in the first place, any proper screening of people from the outset or even the first few days of their detention. So the scope of procedurally defective will be interesting to see. And also, as Greg touched on, Article 3 and 5, the challenge to detention on the basis of a threat to someone's Article 3 rights, or indeed their Article 5 rights. I think that's going to be very difficult for the Secretary of State to say, sorry, within the first 28 days, we can't detain you. And lastly, in terms of habeas corpus, it's one of those things that it almost became a slight joke that you would sort of, if you were relying on habeas corpus in any form of detention challenge, you really were getting a bit desperate. But I think we may be entering a bit like Article 5. We might be entering into an era where suddenly some creative arguments about that will start to have some play. So thank you very much.
Thank you very much, Gordon. So you have Nicola Braganza KC, who is a barrister who practices in all the areas that Greg and Gordon do, but in addition is a specialist in equality and discrimination law. And her practice goes beyond immigration, asylum, human rights, and includes employment law, education, and community care. But she also has widespread experience in bringing very complex, large-scale challenges against the state, particularly in representing highly vulnerable adults and children. And that is also in the immigration context, both civil and public law. And as is foreshadowed, Nicola is going to focus on the reinstatement of the powers to detain children.
Thank you. Hello, everyone. I'm speaking on detention of children. And it struck me, listening first to what Steph was saying, and then Greg, and then Gordon, that we're getting progressively gloomier and gloomier in our presentations. And I'm now rounding that all up with speaking to you about the detention of children, which is really depressing. But the two things I'd flag up, and again, listening to the presentations, is the first, echoing what Greg says about there is hope. We have to go on with the challenges and addressing that to the people in this room and the people watching, and bring those challenges. And the second thing, I think, very much echo what Gordon says, which is that we just have to be more creative. And we are creative, and we just go on doing that, because there is a way around it. I mean, it's been made slightly more difficult, but it's still there. So I'm going to be speaking about, and again, as Gordon was saying, it's slightly shooting in the dark because we don't have the regulations, so we don't know what is going to be set out in respect to the detention of children. So I'm going to first be speaking a bit about how this detaining children is currently being justified. In fact, when you drill down, it can't be justified. What the relevant provisions are, which Gordon spoke to as well, and then where next. So, how is this justified? Right, I'm going to play you, because I don't understand it. Let's see if this works.
The policy objective here is not to detain children, but it's important that we don't inadvertently create a policy that incentivises people to bring children who wouldn't otherwise come here. And that's why it's important that it applies equally to families, because otherwise you increase the likelihood that people bring children here. They make very dangerous crossings. I don't think anyone would want to see that. That's not good for children. So the policy should and must apply to families. But it's right that then we then look at families differently as we do, and they should be in accommodation that's appropriate for them, and that those family groups should not be separated. I think that is the right thing to do, because otherwise, you create, as I said, you create an incentive for a criminal gang to tell people to bring a child with them when they otherwise wouldn't be. And I don't think that is a good thing. I don't think we want to create a pull factor to make it more likely that children are being making this very perilous journey in conditions that are appalling. I don't think that's the right thing to do. We should not create a system that makes that more likely.
No. So that's meant to explain detaining children. It's all about the pull factor, and it's all about getting rid of any incentive by having these powers to detain the most vulnerable. Right, so the incentive. There are three assessments that I was able to find. There's one, the Child Rights Impact Assessment, and note here, it's pre the regulations coming out. So obvious question will be, when the regulations do come out, where is the assessment and what does it say about them? The second is an equality impact assessment, which doesn't really tell you much at all. And then there's the third one, the impact assessment, which also doesn't really shed any light on it. But they are in existence. I've put the links on the slides and we'll circulate them after this talk. So you can, if you can stomach it after that video, look at those too. So the Child Rights Impact Assessment refers to the UNCRC and again speaks to this supposedly perverse incentive for people smugglers to prioritise children and families with children for dangerous crossing across the channel. Families and children come to the UK illegally, are not exempt from detention or removal under this bill. The Home Office already has the power to detain for the purpose of removal, but detention for the purpose of removal is limited to a maximum of 24 hours, and unaccompanied children can only be detained in a short-term holding facility. The assessment, the Child Rights Impact Assessment, goes on to say that the circumstances in which unaccompanied children can be detained are to be prescribed in regulations. So as I say, we're in the dark as to what those regulations say, subject to the affirmative parliamentary procedure, and again repeating that they will only be exercised in very limited circumstances, but not telling us any more than that. And therefore, the purposes when unaccompanied children are being removed for the purpose of reunion with a parent or where removal is to a safe country of origin. Where a decision is made to remove an unaccompanied child under 18, again, detention will be for the shortest possible time, but not saying any more than as to what that time is going to be or limited to, in appropriate detention facilities with relevant support provisions. All well and good, but let's see what these regulations say to bear any of that out. The Home Office is not currently in the position of corporate parent to any unaccompanied child. It will continue to be for the local authority where an unaccompanied child is located to consider its duties under the Children Act. It refers also to the articles, and I've set them out there, relevant to detention, and I'll come back to that in my later slides, and to section 55, so all the, as you'd expect, the relevant flags are being raised. Question the extent to which any of those will be duly respected, and safeguards put in place to implement them. And then it sets out at the end with respect to the detention of families with children, the implementation of Articles 3, 9 and 23. It is assessed that the impact will remain neutral, which in the absence of regulations, I find it's a nonsense assertion to make because it can't in any way be tested. And the assessment goes on to list how these impacts, these negative impacts that apparently don't exist, will be mitigated. Again, ensuring detention powers will be in very limited circumstances, ensuring it'll be for the shortest, detention will be for the shortest possible time in appropriate detention facilities, and then when developing the accompanying policy to accommodate the legislative changes on detention of children and families with children, we will work with the Department of Education, continue open dialogue with the Family Returns Panel and Children's Commissioner. I mean, again, as we go through the slides, all of this makes no sense at all. It's directly undermined and contradicted by what we then find out as to what's set out in the Act and what the proposals are. Build upon our current detention facilities for families to ensure they are appropriate and provide safe and secure accommodation. So the statistics, according to the impact assessment, question mark how reliable they are. I've set them out there. They've said 2022, 5,242 asylum applications from unaccompanied asylum-seeking children. And again, having these statistics in mind and what Gordon was saying is if they're going to be detaining all these children, they simply don't have the capacity to do that. And I've set out there previous figures, 2019, 3,775 of these, 70% were age 16 or 17. 2016, 47% found to be adults, and then to the year end 31st of March 22, 5,540 unaccompanied asylum-seeking children cared for by local authorities in England, an increase of 34%. So then there is the equality impact assessment, which again doesn't really enlighten and just makes for further more depressing reading. That sets out that whilst judicial review will be restricted, however, applications to the High Court for a writ of habeas corpus will be permitted at any time. An individual will also still be able to apply to Secretary of State for bail at any point. The bill provides unaccompanied children may only be detained for purposes prescribed in regulations. Again, regulations unseen, unknown at present. And those regulations also permit time limits to be placed, and the link is there. Section 149, what about the discriminatory impact? And think back to the clip I showed you at the outset about this deterrent effect. So the equality impact assessment says it should have a deterrent effect. So again, I mean, that's the best that can be said. It should have a deterrent effect, which can result in fewer unaccompanied children arriving in the UK by dangerous and unlawful means. This serves to mitigate in the long term how many children will arrive in the UK, which impacts on the risk of children absconding. This approach is designed to safeguard the most vulnerable and ensure that, I mean, it does read almost like a bit of a black comedy in its darkness, but it goes on to say, and again, so think back, what is the justification for this? How is it made out? And I can't remember now whether it was Greg or Gordon saying that there's the theatrical and the rhetoric element of all of this. So it's, again, in the absence of what these regulations say, it's very difficult to know what the line is of what's intended. So this deterrent effect that is so confidently asserted as existing, in fact, according to the Home Office's own document, the bill is a novel and untested scheme, and therefore uncertain what level of deterrence impact. So when it comes to challenges and looking at justification, there is no justification. You don't even have to go beyond the Home Office's own documents to see that there is no justification. The delivery plan is still being developed, adjusting for changes during legislative passage. I mean, I think it's, I'll be corrected, but to me it seems pretty unheard of if you think where we were at the beginning of this year and where we are now with what was proposed and how quickly we have arrived at where we're now at with this, with the Unlawful Illegal Migration Act. No displacement effects of migrants shifting to other clandestine routes of entry are included in the core analysis. The baseline does not include impacts of to-be-delivered projects. So it's a pretty pointless impact assessment. And again, I think all that we can do is press for the continuing assessments that presumably are being prepared, specifically in to what I'm speaking about on the regulations for children. And there is no evidence. That's slightly, the bit at the top is hiding where I get to. So that you saw the justification, you saw what's said in the Home Office documents on justification, and actually there is none. As with Rwanda, very interestingly, this letter to the then Home Secretary Priti Patel saying, again, this same phrase, the mantra that's trotted out, deterring people entering the UK illegally, value for money, the policy is dependent on it being effective as a deterrent. Evidence of a deterrent is highly uncertain, cannot be quantified. There is no evidence. I do not believe sufficient evidence can be obtained to demonstrate the policy will have a deterrent effect. So that's on Rwanda. And then we have in response, the Children's Commissioner. Now, I won't read all of that out, but she makes it quite clear. She has deep concerns about the relaxation of rules around detention. And she says, I remain unconvinced it's possible for the Act to be implemented in a way that is compatible with the Children Act. Joint briefing by the Refugee and Migrant Consortium, Children's Consortium. So what's the impact? Home Office own guidance, stating a period of detention can have a significant negative impact. You don't say. Of course, we know that. Previous research conducted in the UK evidenced the long-lasting damage detention does to children's lives, all of which undermine the importance of having proper justification when measures of this kind are brought in. And then specifically answering my question, the pull factor. No, there is no pull factor. And again, this is from the Joint Child Detention Briefing. Continuing to have limits on child detention will not increase the number of children coming to the UK on small boats. Once routine child detention was ended in 2011, there was no proportional increase in children claiming asylum. The Joint Committee on Human Rights, in looking at the removal of location and time limits on child detention, considered the government's desire. The committee stated, "We have not seen evidence that this is likely to happen, nor that it would justify detaining children for periods previously considered to be excessive." So that is why we go back to that first clip. I think it's fair to say there was a slight prickliness in the defending of the detention of children, and that prickliness, putting it at its lowest, is no doubt because any proper testing of what's been inserted to justify this quite horrific and draconian and unnecessary and inhumane measure is that it doesn't exist. So what's the power? Gordon spoke to that. It couldn't be wider if you tried. Where the immigration officer suspects the person meets the 4 conditions and you would take him to the 4 conditions, he may detain pending a decision. He suspects there's a duty to make arrangements, he may detain pending a decision. If there is such a duty, pending removal, and if they're met but there's no duty, more. Pending a decision to give limited leave, pending a decision to give leave under 8AA, discretionary leave, pending a decision to give leave for victims of trafficking, pending a decision to remove an unaccompanied child. Pregnant women, Gordon had that within his slides as well and said, yeah, there's slight, well, anyway. As I said, it just gets gloomier and gloomier, but a slight reprieve there for pregnant women. Unaccompanied children. So the duty does not require the Secretary of State to make arrangements, but the Secretary of State may make arrangements for the removal. And then setting out section 4.3, the power may be exercised only for the purpose of reunion, removal, and where there's no protection claim or HR claim, the person is to be removed to a country for which they're a national, have ID, or country in which the person embarked from, or as may be specified in these regulations. So, wait for these regulations, and no doubt we'll put on some more seminars about how to challenge those. And then defines unaccompanied child. So C meets the 4 conditions. C is under the age of 18 at the relevant time, entry, arrival, no individual, whether or not a parent of C who was aged 18 or over had care of C. Again, think back to when I took you to the child rights assessment, the quality assessment, and then go to the, or maybe don't go to the explanatory notes. They're here, and the explanatory notes don't explain anything. All they do is to say, these are the benefits of the IFRP. The panel provides advice on safeguarding and welfare, making recommendations, ensuring welfare needs, and then there's a line that says, and now that's disapplied. And that's all there is. There's nothing more by way of explanation. So in terms of what we do have, so currently, as was I took you to at the start, the powers are such that there's a maximum of 24 hours and an unaccompanied child may only be held in short-term holding facility and no other place except either during transfer, while being taken in custody, and only while directions requiring the child to be removed. So that's the current position set out there. Now, Section 11.2 sets out, again, that's where you find the provision about the regulations that are going to come in to bring this into force in terms of how unaccompanied children are then to be detained, and that these regulations are also going to speak to time limits. Power to grant bail, that's this way you have the ouster clauses, and for children, the end of the period of 8 days beginning with the date on which the person's detained for unaccompanied minors, and then no challenge in that time, which again Gordon spoke to, unless bad faith or procedurally defective ways amounts to a fundamental breach of principles of natural justice. And again, I very much echo, it shouldn't be based on past performance, too difficult to find a procedural defect. So implications await the regulations. We obviously have section 55 to cling on to. Articles 5, 3, and I also put in 14 Detention of children in inappropriate accommodation can potentially engage Article 3, case of Pop-Off in France. Cannago-Ratnam in Belgium, which was the court found a violation of Articles 3 and 5 in respect of a mother and her 3 children who were detained in a closed transit centre. Consider Article 14 because relying on other status of unaccompanied children seeking asylum, and they're being detained without justification. So they're being treated differently by reason of the detention. There's no justification, certainly none in any of the documents that I was able to find and have taken you to. Failure to take account of the best interests of the child can render the decision to detain unlawful. That was in respect of Mr. O Ceallaigh, who was detained and his children, the best interests of his children not being taken into account in respect of his detention. And then there's the case of ANFA, a practice of detaining children for the purpose of conducting so-called illegal entry interviews. So I think really all we can do is press on, as soon as we get the regulations, press on whatever assessments there are on the regulations, press on justification and how that continues to be relied on, press on data gathering, which is met with a lot of resistance, but I think we just need to press on that and then bring challenges relying on, as I've set out, the various international instruments and then domestic law with ECHR. Section 55 and the guidance, relying on that, and in the way that Section 55 incorporates what the Convention on the Rights of Child provides. And then I've set out there the importance of ZH Tanzania, highlighting the importance of the best interest of the child as a primary consideration. And then I end with the UNHCR's guidance. The clear view is children should not in principle be detained at all. See the UNHCR detention guidelines, specifically 9.2, adopting the wording of Article 37. No child shall be deprived of his or her liberty unlawfully or arbitrarily. Measure, if used as a measure, must be used as a last resort. Every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner which takes into account the needs of persons of his or her age. No doubt the regulations will reflect this. And every child deprived of his or her liberty shall have the right to prompt access to legal and other appropriate assistance, which is where we come in, as well as the right to challenge the legality, which is what we have to keep doing. So I'm so sorry that there's nothing positive to say about this. But yeah, just have to keep fighting. Thank you very much.
So there's an opportunity for questions, and anyone got any burning questions? We're all too depressed to ask a question. Yeah. Sorry. Elspeth.
Hi, Elspeth from Medical Justice. Just a really basic question from a non-lawyer. The provisions that come in tomorrow, do they apply to anyone that's in detention, no matter when that detention began, regardless of whether today they've got that right to?
My reading of it, absolutely yes. So like I have an interim relief hearing come up where that may be an issue. And if you're in detention at the moment, I think it's arguable on the Secretary of State's interpretation, as I anticipate it to be, that your detention's unlawful today, but tomorrow it's fine.
More gloom.
That's if they succeed in the interpretation.
Is there an argument, at least? I mean, I think once they do a new detention review, then it's already established from Kembarzi that that's a authorization for detention. So I suppose there's a weird hiatus where it could be a retrospective application of the law, and that might be an argument, but it's not going to last very long because it's a fresh authorization, isn't it? Once they do depends where you are, but like if you've been in for a little while, 28-day review.
That sounds right to me, yeah.
Hi, the question I've got is with regards to the safeguarding of children, particularly given the fact that the Secretary of State has said that they're not going to be the corporate parent of the child. I know that there was a recent decision brought by the Good Law Project, the Article 39 case, which said that even without express statement, the local authorities would have responsibility over children held in detention. Is that going to be the case in this instance, even where the Secretary of State holds on to the child without giving it to the local authority for a certain period of time, do you think a court would still find that actually the local authority does have that sort of protection interest?
Yeah, I think I suppose it'll depend on what the regulations say on it. But yeah, I think it would do in terms of it's difficult to anticipate.
There is a relevant case actually which followed on from the Article 39 case, which concerned the use of hotels and the accommodation of children in hotels, which were said to be outside of the care of the local authority. So there was a recent judgment on the 27th of July in ECPAT brought a case against Kent County Council for not exercising its statutory duties under the Children Act, and against the Home Office for basically agreeing an arrangement with Kent to do that. And I represented, unusually for me, Brighton and Hove City Council, who brought a claim against the Home Office because they had a hotel in their area, and as a result, there were seven hotels in about 5 locations. And basically, for about the last 2 years, most of the hotels had operated on the basis of the Secretary of State's assertion that they didn't owe Children Act duties. That was obviously wrong. The Article 39 judgment, although it only concerned the duties to missing children, made that clear, and the Home Office promptly changed their position and told all those local authorities actually you do have duties, although they couldn't meet them because they got 70 children and over 1,000. I think Brighton had nearly 2,000 children in 2 years going through the hotel with no provision to make resources available to meet the provision. So the current position, which is set out in the judgment of Mr. Justice Chamberlain, is that although Kent County Council has the primary duty, because all children that come through Kent, they have to take them into local authority care. Local authorities in areas where they're transferred to would also have duties because they meet the threshold. These are unaccompanied children who are obviously highly vulnerable, and they not only would they have the investigative duties under Section 17, but very likely accepted under Section 20. So if you had as well, even though they're accommodated in hotels, the law is under the Children Act, roof over your head doesn't meet all your needs, and so Brighton and the other authorities also had duties which they were not complying with. And when the Home Office stopped using hotels temporarily but decided to stand them up again, Brighton brought a challenge to prevent the children being unlawfully transferred into their area where they were not in a position to meet those statutory duties, and that was successful. So if a child is in a detention centre in the area of any particular local authority, there's absolutely no question that the local authority in whose area they are present will owe duties to them. And I think certainly, I don't know, maybe others can remember this, but at the time at which, towards the end of the use of the detention of children in families, there was an attempt to engage local authorities in the, were they in Oakland? No, they weren't. Campsfield. In the area where they mainly held, I don't think it wasn't Brookhouse, to engage local authorities to actually exercise their duties to oversee and monitor what was happening to children who are held in these facilities. So there's no question that local authorities will have their full safeguarding and other duties to those children if they're in their area. It's an interesting judgment to look at because unusually, well, for the first time, Mr. Justice Chamberlain used his power to make a suspended quashing order. And he did that because there was no circumstances in which overnight Kent and the Home Office were going to sort out the systemic illegality that they've been operating for the last 2 years. And although I think if that power was seen as a retrograde step, it allows the local authority, the public authority, to not have to implement and comply with the law immediately, which should be the normal effect of a declaration and a quashing order. It has been used and is continuing to be used to oversee the implementation of the judgment. And although it's counterintuitive, where you've got a government that does not respect judgments of the court and appears to be incapable of responding to the requirements of the rule of law, having court scrutiny is making a difference to an actual implementation of the ruling. So it's an interesting judgment to watch, where you've got systemic challenges that affect a large number of people, and you get that judgment, but then you find nothing's actually happened. This power that's being used in that case may be of assistance. Any other questions?
I was just saying, so when you've got, obviously there's a lot of unknowns with detention of children, but when you do have that, I'm so sorry, I'm a medic, so not a lawyer, working for Forest Medical Legal, so you've got doctors working within the system, not always a great thing. So you rely on cases being raised by lawyers who then, sort of ask us to go in to make an assessment. What facilities are they going to have for medics to be within there to highlight safeguarding concerns or mental health needs? You've got children that are currently, that I work with outreach, are housed in hotels. Are they going to suddenly, because they've come in illegally, going to be picked up and plopped into detention? And we know some of them have got huge mental health issues. How, because their medical cases, even though they're electronic, don't follow. So, and they're so high risk. Who's got eyes on them, and who will have eyes on them, if at all anyone?
Nicola?
I have no idea what we have in place to look out for that.
One of the things that came out of the Brook House inquiry, one of the major themes, was the inadequacy of medical care and medical screening. And I think it was, even for those of us who've worked in immigration detention for a long time, it was jaw-dropping. The evidence of the doctors when they were called to account in the inquiry was jaw-dropping. And just very, very basic misunderstandings as to how the procedural safeguards work. So Rule 34 and Rule 35 of the detention rules. Doctors didn't understand what they were supposed to be doing. The oversight from the Home Office was nil. And it was an incredible piece of evidence which came out that, having essentially misapplied Rule 34 and Rule 35 for about 5 or 6 years, the doctors that were in the Brook House were then given a contract to train doctors in all the other detention centres by the Home Office. So I think the answer is in two parts. Firstly, we don't know what provisions they're actually going to make. But the second part is that whatever provision they do make, if past history is any guide, will be wholly inadequate.
I think, to add to that, there was not just completely, whether deliberately or by incompetent misunderstanding the rules, they actually said that the time that's allocated to do a Rule 35 mental and physical examination was no more than 5 minutes. So it's simply not possible, and they knew it was not possible, and they had unlawfully, and she said inappropriately, disconnected Rule 34 and 35 so that they weren't operating. And I can't remember the actual figures, it'll be there, but they were saying they could only do, I think it was 5 Rule 35s in a day. Might have been less, but it was a tiny number if you think that is all supposed to take place for everybody within the first 24 hours who come into detention. And the government the Home Office was not paying them. They had not made arrangements for those rules to be implemented. And that won't change when that's for people with histories of torture, trauma, mental health problems. They're not going to treat children any differently, because they don't distinguish, do they? It's all about deterrent.
If you look at what happened in Manston as well last year, when there was a sudden, it's a sudden detention of large numbers of people, and they were not ready for it. And what happened in there medically was really, really troubling. And a lot of people ended up being sent around the country when they were released who were quite ill and took communicable diseases with them. So past form wouldn't suggest it's going to go very well.
There's a person at the back.
Sorry, I just had a clarification question. So the regulations around children's detention, is that just for unaccompanied children or families as well?
Well, they haven't come out yet, so it says that the regulations will provide for detention of both.
So it could be in both.
That's my understanding. Yeah.
Yeah.
Hi, yeah, thank you all for the very thorough, if bleak presentations. A quick question about section 13, ouster. You mentioned potentially relying upon an expansion of habeas corpus. I know habeas corpus is quite limited. I was wondering if you could explain a little bit about what you were thinking to the extent possible.
Sure. I mean, there's obviously a slight element of clutching at straws, but I think so. If you look at the way that detention, particularly immigration detention cases, have evolved over the last sort of, I suppose, 30 years or so, whenever there's been an attempt to try and limit the court's jurisdiction, they have, to be fair, generally thought it with an F. The case of, there was an example of the case of, is it Jallow? Yeah, Jallow. The case of Jallow was a good example where the Secretary of State wanted to argue that it was time essentially for the definition of deprivation of liberty in the common law to mirror that in Article 5. And the Supreme Court kicked back on that quite strongly and said, no, that the way that the common law has evolved is as one of the bulwarks, one of the safeguards against arbitrary detention, and that ought to be permitted to be part and parcel of people's protections. So I can see a scenario where if an action is prevented by an ouster clause, but a court can see that the underlying detention is illegal, the lacuna, the gap will be filled by habeas corpus in those scenarios. How that plays out will remain to be seen. And I suspect that what will happen will be a sort of chipping away. So there'll be cases where Article 5 is pleaded, there'll be cases where Article 3 is pleaded, there'll be cases where procedural fairness is pleaded, and there'll be cases where habeas corpus, and obviously combinations of all of those things. And then we'll get a new body of authority, which hopefully will be along the same vein as we've had. Because, I mean, say what you like about the courts, they have been reasonably consistent about there being a line in the sand with regard to administrative detention. And so that has slipped a little. I mean, cases like Sardi and the detention fast-track cases were, potentially a bit of a slip, but overall there is some, perhaps this is a good way to finish this answer. There is some reason to be hopeful that there'll be some degree of guardianship over the principle.
Habeas corpus is not intended to be useful in the Act. Well, habeas corpus is it's essentially a remedy, and they're basically providing that detention will be pretty much legal in all circumstances. So when you come to get your remedy, how useful is it going to be? But what habeas corpus provides is that the Secretary of State will have to bring somebody before the court and give an account of his illegality. And it may be that if you make them do that, there are things that you'll bring up in court that will make it difficult for them to justify continued detention, I think.
We also have to try and agree how to pronounce it.
Yes, sorry.
The whole thing and spell it is really hard. I think they left in habeas corpus because they were responding to the wing within their own party that says, there's these traditions of protections for civil liberties in the common law. So it was for David Davis, you will still have habeas corpus. And obviously it was also part of setting up the challenge, which is evident throughout the whole litigation, with the convention being the backdrop rather than so that there'll be clashes constantly. If you win, it's going to primarily, they think, be because Article 5 or Article 3 gives you something that now has been taken away from the common law. But I would not be so pessimistic about the use of habeas corpus, because let's not forget, it did bring the king under the power of Parliament. Let's dust off the ancient writ. It only got sidelined because judicial review filled the post, and it was more convenient, and it wasn't, but it is there. The key distinction, I think, is what does it mean to say that there's no power? So the distinction between no power and the exercise of the power. And that argument has been played out in a number of cases. But the last word on it is Lumber, and Lumber says there is no difference between the existence of the power and the exercise of the power, which is why a failure to apply a policy that wasn't published was a nullity and unlawful. So I think that those arguments will come back. And and it is a question of will on the part of the court, whether it will use the writ as it was used historically to underpin the rule of law, and that's the question and the gauntlet for the courts. And we have to put that to them, that they're going to be disregarding that fundamental role of the habeas corpus in retaining and underpinning any notion of rule of law, and are they going to empty it completely of its content? We'll have to see. Has anyone got any other question? There's a couple of things that might be worth just raising is in terms of Article 5, I think you talked a lot about, I think mainly on the basis of perhaps interpretation and Section 3, but what do we think about compatibility given what you said about Article 5 mirroring the Hardell-Singh principles and that being the case from the case of JN in Strasbourg? Do you think we would be looking to say, is it going to be Section 3 or is it going to be Section 4 or both? How would you approach that?
I think I think the legislation designed to oust Section 3. So we're kind of stuck with that. I mean, the way I've been kind of thinking about it is that you'll say, well, you don't have to read the legislation compatibly with the Human Rights Act, but if you detain somebody, it's a breach of Article 5, you have to let them out. And it's a lumba error, and it entitles you to damages for false imprisonment, just like any other lumba error. So I suppose in theory you could go for a declaration of compatibility, but I just think that kind of plays into their hands really, but they're setting it up, as you say, for a battle with Strasbourg. Don't tell them points to that as the reason that they can't put people in detention. So I would just run straight Article 5 points, I think.
The Act says at the beginning, doesn't it, that specifically Section 3 isn't to be.
Although that's not enforced yet. So this has come into force beforehand.
Yeah,
you could try and interpret
it until it does.
But I think then that would just make them bring that section into force, I think.
Yeah.
So.
And then the one other thing I was going to just raise, because of the interrelationship between the Hardell-Singh Principle 1, which was saying use it more because is it for the purpose? And because these new powers are related to the power to remove, and apart from Albania, the only option is Rwanda. So how is that going to be an argument that's going to arise in every case? Because until the Supreme Court rules on whether they can use the possibility of removal to Rwanda.
Yeah, I think that's why I sort of began by saying that there's a question as to how much of this is performative and political and theatrical rather than actually ever meant to work, because there are all sorts of problems. I mean, for one thing, the 20th of July has been and gone, so everybody that's come since then technically is subject to all these removal provisions, and when they come in the detention provisions. So I think there's been some wide-ish interpretations of what it means to be pending deportation and pending removal in the past that have justified people being in detention for years and years and years. So one would hope that sort of pointing at a sort of 100-bed dormitory in Rwanda and saying that's where our 30,000 people that are subject to this are going to go wouldn't be enough. But one never knows. So I think it's going to be sort of grimly fascinating to see what they actually do with it. Because I think my gut instinct is that they won't actually do anything with it. That we're all completely wasting our time. No, but I think there is a strong element of that. If you actually look at the practicalities of any of this, it's just really hard to see how anything other than a few really unfortunate few dozen of people are really going to ever be subject to it. But we'll see. I hope I'm right, because it's going to be incredibly grim if I'm wrong.
It will take nearly 4 years to bring in all the bail provisions about GPS monitoring and sort. That's how long it took them to sort that out. This is much more complicated and difficult, I would think.
And they don't have the detention capacity. And Brookhouse, they've got to respond to Brookhouse in 6 months. And Brookhouse essentially, it just shone a light into how bad just conditions were, let alone treatment. And so you can't provide immigration detention capacity at a drop of a hat. So I think a lot of this has got to do with the next election and Suella Braverman's run at being the next Prime Minister of the United Kingdom. will help us.
Yeah, and I certainly would say if they do ever get to implement to detain children, looking at the conditions as has just been said, forget about the abuse, as Gordon says, it's those conditions. Children cannot be in those conditions, and it can't be compatible with Article 3.
Also,
And Article 5, because the disproportionate, the relationship between the Idea case, if it's unacceptable, so that was the case about holding immigration detainees in prisons, and the test that was set there. There's no circumstances, I can't believe, that they could show that those conditions, the general conditions, are in any way acceptable for children.
but also you can start looking at the cases, the third country cases we used to do about Italy and Greece, like what MSS against Belgium and Greece says about conditions for children, and what Tarakel against Switzerland says about conditions for children. I think we may have to start applying those standards in this country if that's what's going to happen.
So I don't know if there's any questions arising out of that, but I think we are all left with a number of questions. What will the common law provide for us? Will the courts continue to hold the line and to ensure that it does deliver on protecting the rule of law? Are we in for just a series of Pyrrhic victories or Pyrrhic losses for the government that they will then paint as just another reason to get rid of the Human Rights Act if Article 5 and 3 become the bottom line as opposed to the common law? And I think the big question that's been raised is this really propaganda or law? Is it ever intended to be implemented, and can it ever actually be implemented? But nevertheless, it creates grave uncertainty for people who fear that they may be subject to it or here, particularly young people. And there's already a lot of material about the impact of the hostile environment on children going missing, and children not having confidence, or adults not having confidence in the system. And why would you have confidence in a system that is based on both gross incompetence to implement it and abject cruelty, and obviously a fundamental disregard for basic rights to have an asylum determination and to be treated with anything like basic human dignity and respect? And so lots of questions. I hope we've given you some potential answers, and if that isn't enough, we also have further seminars which you may be interested in. They're coming up that look at the other aspects, because obviously this legislation couldn't be more wide-ranging in the whole field of asylum and immigration law that it affects. And on the 11th of October, there will be another hybrid event on the illegal migration bill that relates to the removal powers, specifically the limbo that people are likely to be in, age assessments, and the impact on trafficking and exclusions. Followed then on the 29th of November by another part 3 of the Illegal Migration Act seminar, which will look at third country removals and interim measures. And finally, on the 22nd of November, not limited to the Illegal Migration Act, but there is a half-day conference that Garden Court is putting on in its Child's Rights group, which is about children and detention, not limited to immigration detention, use of detention of children elsewhere. And again, the Brookhouse inquiry has some resonance for general detention, because one of the key things that it said was that the use of prison control and restraint forms of force, which are based on prison methods, should not be being used for the different cohort of immigration detainees, given their vulnerabilities. And that would equally apply to the extent to which those constraints, those control and restraints methods are used on children in other facilities, in secure training facilities, etc., then it may have some resonance there also. So if children's rights is a focus, then this will give you some wider information about current issues in that area. So yeah, there's plenty to continue to hopefully not be depressed about, but to engage in, and to improve our ability to take the fight to them. And if you want to have a look at other work that Garden Court's been doing on seminars in related topics, then you can go to the YouTube channel. And if there's any time in between, I think now's the time to go and have a drink, perhaps some food. And I hope we'll see you downstairs. Thank you for coming.